Good morning. I am at-large council member Anita Bonds, chairperson of the Committee on Executive Administration and Labor. The time is 10:03 a.m. on Wednesday, June 28th, 2023. We are meeting in room 123 of the John A. Wilson Building and virtually via Zoom to convene a public hearing on 3 bills. The 3 bills are 25-130, Short-Term Disability Insurance Benefit Protection Clarification Amendment Act of 2023. Second bill is Bill 25-234, Minimum Wage Clarification Amendment Act of 2023. And Bill 25-0033, the Commission on Public Compensation Establishment Amendment Act of 2023. Today's hearing is being streamed and recorded on the committee's YouTube channel named EAL Committee. It is also available on the DC Council website at www.entertainment.dc.gov. Let's start with Bill 25-0033, the Commission on Public Compensation Establishment Act of 2023. It was introduced on January 13th, 2023 by Council members Henderson, McDuffie, Gray, Lewis, George, Parker, Fruman, Nadeau, Pinto, and I co-sponsored it. The bill will repeal the inactive Mayor and Council Compensation Advisory Commission and replace it with a Commission on Public Compensation. The legislation would establish an advisory commission to review and recommend the compensation or stipend levels for 20 public commissions and boards and the salaries for the mayor, the attorney general, members of the council, members of the State Board of Education, and several significant full-time boards, including Advisory Neighborhood Commission, Alcohol Beverage Control Board, Board of Elections, Board of Ethics and Government Accountability, Board of Zoning Adjustment, Contracts Appeals Board, Concealed Pistol Licensing Review Board, DC Retirement Board, Higher Education Licensure Commission, Historic Preservation Review Board, Housing Authority Board of Commissioners, Office of Employee Appeals, Police and Firefighters Retirement and Relief Board, Office of Appeals, Employee Appeals, Public Charter School Board, Public Employees Relations Board, Public Service Commission, the Real Property Tax Appeals Commission, Rental Housing Commission, Washington Metro Rail Safety Commission, and the Zoning Commission. This advisory commission would consist of 11 voting members, 7 appointed by the council and 4 appointed by the mayor. Bill 25-0130, the Short-Term Disability Insurance Benefit Protection Clarification Amendment Act of 2023, was introduced on February 8th, 2023 by council members Lewis George, along with council members Robert White, Nadeau, Parker, Allen, Gray, and myself. This bill would prohibit private disability insurance providers from reducing benefit payments for district workers based on the amount of universal paid leave benefits the insurer expects the employee to receive. This legislation also prohibits the reduction of benefits under these circumstances, regardless of the jurisdiction in which the insurance policy was issued or written. And finally, Bill 25-234, the Minimum Wage Clarification Amendment Act of 2023, was introduced on February 8th, 2023 by council members Lewis George, Robert White, Henderson, Pinto, Nadeau, Parker, Gray, Fruman, and myself. And this bill would require that employees pay full minimum wage to employees who work at least 2 hours per week in the district. Currently, minimum wage is only required for employees that work more than 50% of their work time in the district. This leads to some employers rotating employees in and out of the district to avoid paying the district minimum wage. This bill would eliminate this form of wage theft, leveling the playing field so district workers are properly compensated. I ask that today's witnesses keep your remarks as brief as possible. We are allowing 5 minutes for everyone to make their comments, and everyone will be heard. I'd like to note that the entire written testimony will be a part of the record. So if you have not submitted your testimony, please email it to CEAL@dccouncil.gov, and CEAL is CEAL @dccouncil.gov. At this time, I'm going to recognize, I see several of my colleagues, and I want to recognize them. They may want to make opening statements. Councilmember Henderson, I think I saw you first, and then of course, Councilmember Lewis George. And both of these colleagues have introduced legislation, so it's important to hear from them today. Councilmember Henderson.
Thank you, Chairperson Bonds. Can you hear me? Okay, I think she can. Good morning to you. Good morning, Councilmember Lewis George, and to all of the witnesses who are here. Thank you so much for holding this hearing today. I'm going to briefly speak to one of the bills that I introduced, the Commission on Public Compensation Establishment Amendment Act of 2023. Unfortunately, I can't stay for the whole hearing because I'm chairing a hearing in the Committee on Health in 20 minutes. So I'm going to be very, very fast. I introduced this bill last year in July with the hope of establishing a commission on public compensation to review and make recommendations on the compensation and stipend levels for members of the council, the mayor, the attorney general, members of the State Board of Education, and several public boards and commissions. Although the council passed legislation in 2006 to establish an advisory council to look at the compensation levels for the mayor and the council, based on review of records, it was never active. At the time, the district attempted to engage in a comprehensive study of compensation and stipend levels of the district's boards and commission. At the time, the last time that the district has sort of engaged in this work was 2002. It is time that we get this right and really engage in this conversation if we want to continue to be able to recruit excellent individuals to serve in roles on important boards like the Alcohol Beverage Control Board or the Public Employee Relations Board. We should ensure that individuals are being appropriately compensated for their work. Many states, including Maryland, Delaware, Hawaii, New Jersey, Missouri, Oregon, and Washington, use some type of compensation commissions to inform their salaries set for elected and judicial officials. Currently, there are 21 boards and commissions in the district where members receive either compensation or stipend for their work. However, some have argued that others, like advisory neighborhood commissioners, which are elected, should be included among that group. Part of the charge of the Commission on Public Compensation will be to consider this and make recommendations to the council for any appropriate stipend level, if any. The commission is structured to work over the course of the year and provide a report and recommendations to the council and the mayor in a time frame to be considered and incorporated in the fiscal year 2026 budget. So that's 2025. This bill also had a hearing in December during council period 24, where we did hear from some ANC commissioners about this and the positive impact that it would have on their ability to serve as well. I recognize we have no public witnesses signed up today, but I hope if the committee chooses to move forward, they might incorporate some of the testimony from that hearing. I look forward to working with my colleagues as we continue to establish healthy government practices here in the District of Columbia. Also, Councilmember Bonds, I just wanted to express appreciation for you holding a hearing on Bill 25-0130, the Short-Term Disability Insurance Benefit Protection Clarification Amendment Act. I worked on concert with that with former Councilmember Alyssa Silverman when she was chairing this committee, and I was a member of the Labor Committee. But I think that Councilmember Lewis George is going to speak to that. So thank you, Councilmember Bonds.
Thank you very much for your remarks, and Councilmember Lewis George.
Good morning, and thank you, Councilmember Bonds, Committee Chair, for holding today's hearing, which includes two bills I was proud to introduce this council period. The first bill is the Minimum Wage Clarification Amendment Act, which would guarantee all people who do work in the district the full minimum wage of $17 an hour, the highest minimum wage of any state in the country. Paying good and fair wages not only make our employers more competitive for great and loyal talent, but it helps working families to better meet their basic needs and break cycles of poverty that have too long plagued many in this city. However, like most states, DC determines qualifications for wage rates based on where a worker spends a majority of their time. And when someone works in a sector that has a less predictable schedules and job sites, those workers are vulnerable to a loophole that allows an employer to revert to paying them less than the district's required minimum wage. This is a perverse incentive for wage theft. I look forward to working with you, Chair Bonds, and DOES with this committee to move this legislation through swiftly this fall so that all people working to rebuild our vibrant city receive the full and fair pay they are owed. The second bill I am looking forward to discussing is the Short-Term Disability Insurance Benefit Clarification Amendment Act. This is a technical clarification bill that seeks to eliminate the manipulative practice of short-term disability companies padding their bottom lines by using the district's universal paid leave program to offset the insurance benefits these companies owe to workers. It's quite simple. If you or your company buy into an insurance plan, then you should be able to fully access those benefits you pay for. And yes, this means that in some cases, a worker will be eligible for two sources of benefits or to receive more than 100% of their usual pay. Again, if you paid for these services, you deserve them in full. The district's paid family and medical leave insurance is about sustaining working families through major life milestones and in times of medical crisis. It is about creating cost-effective ways for district employers to provide paid leave and retain their workforce. It is not about using a social insurance lifeline to subsidize costs of private market insurances. And yet, on a regular basis, my team receives calls and emails from constituents seeking guidance on the offsetting practices of various short-term disability providers. Constituents ask us, how is this legal? It is clear this practice is still happening despite the temporary laws we have passed in recent years to clearly prohibit offsetting. It's time to take action with a permanent law that empowers our Department of Insurance and Banking to protect working families and enforce prohibitions on offsetting regardless of where the policy was executed. I also want to use this statement to note that given the opposition testimony I expect we will hear today from private insurance industry, that I believe the final bill we pass will need to be strengthened against any sort of corporate manipulation in the following ways to protect DC workers and DC Universal Paid Leave Fund. First, we should add paid leave offsetting to the list of deceptive practices prohibited by the Consumer Protection Procedures Act. This could empower the Attorney General to be a partner with DSB on enforcement. We should also require DSB to conduct a robust public awareness campaign for district employers and employees to help them choose short-term disability companies that will comply with the district law. It is incumbent upon DSB to help expose the type of problematic offsetting rider language a consumer should be looking for when reviewing and deciding upon an insurance policy. And finally, we should look to legislative language and enforcement practices that mirror DSB's ability to go after extraterritorial health insurance who do not comply with the district laws. I understand there may be some questions as to whether DSB is actually doing this sort of enforcement. So I hope this bill moves forward to the Business Committee also so we can dig into this topic further. I am grateful to the public witnesses and Director Morris Hughes for being here today to testify and share your insights on ways the district can further strengthen its workforce, raise wages, and protect benefits. And again, a huge thank you and appreciation to Councilmember Bonds and her staff for bringing these two legislations for a hearing so that we can hear from our witnesses on this. I will have a hard stop today at 12 p.m. in order to attend school readiness and work order oversight tours that I am doing as facilities chair. So I will apologize in advance for missing the end of today's discussion. Thank you.
Thank you very much, and special thanks for including my staff in the review of these schools. It's very good. It's going well because
Yes.
you're weeding it out, and we should be in much better shape.
That's right. First day of school.
September. That's the whole idea. Yes,
that's right.
indeed.
They got 61 days to get our facilities right.
You're on the case. You are on the case.
That's right.
Thank you.
All right. Thank
So
you.
very, very much for that. So now we will hear from our public witnesses. And regarding Bill 25-0134, the Minimum Wage Clarification Amendment Act, we're going to hear, we have a panel of 4, and I believe they're all virtual. Am I correct? Okay. Zuli Pinda, Fidelica Valaquez, who will need a translator, Steve Lansing, and Nadia Salava. And we will start with Miss Pinda. And you can begin when you're ready.
Good morning, Chair Bonds and members of the committee. My name is Zuli Panetta, and I'm an organizer with the Mid-Atlantic region of the Laborers International Union of North America, also known as LIUNA. I'm here today to speak in support of Bill 25-0134. This bill will close a loophole in which employees need only pay their employees the DC minimum wage when their employers work more than 50% of their hours in the district. This loophole, which has been in effect since the Minimum Wage Revision Act of 1992, has been a topic of discussion in my conversations with workers in DC. I would like to share the testimony of those workers with you today. When the DC minimum wage was raised to $16.10 this past July, our immediate task as an organizing team was to ensure that non-union utility and construction workers were earning at least that amount. One group of workers we targeted was flaggers. Flaggers are traffic safety workers who set up cones and signage around utility and roadwork sites to ensure that safety of utility workers and a safe flow of traffic, oftentimes putting themselves in harm's way to do so. Despite the vital role that flaggers provide to public safety, we quickly learned that many were earning far less than $16.10 an hour. After educating these flaggers on the increase in minimum wage, something few knew anything about, we were directly told by the flaggers at 3 companies that they were earning $15, $14, and as low as $13 an hour for their work in DC. Many of these flaggers were working on Washington gas sites while getting paid these wages. Upon further discussion and receiving flaggers' pay stubs, we learned how and why companies are continuing to pay such low wages. The 3 companies in question are all located in Maryland and consistently shift their flaggers in and out of DC so that per the 50% loophole, they do not need to pay their workers the DC minimum wage. In other words, if a flagger works less than 50% of their work week in DC, they do not need to be paid the DC minimum wage under current DC law. At one job site on 12th Street Northeast, a job that lasted 2 straight weeks, we spoke with 6 flaggers from the same company who said they were being shifted to sites in Maryland and Virginia throughout the week, so the company would not need to pay them the DC minimum wage. One flagger worked in DC, Leesburg, and Baltimore City in a 3-day span and earned $15 at each site. My colleague, Billy Cerullo, and I took video interviews with several of these flaggers. A transcript of these interviews prepared by Billy is attached to my testimony, as well as a pay stub for a flagger who is receiving only $13 per hour at a Washington gas project. The 50% loophole that companies use to cheat their workers out of wages is both archaic and inequitable. The flaggers I speak with need to keep constant track of their hours in the hopes that they will cross that 50% threshold to earn a living wage. Moreover, the loophole is not conducive to public safety. We visited the 12th Street Northeast site every day for a full work week and saw that flaggers were different every day, which means they had to relearn their surroundings and the flow of traffic as opposed to having a consistent crew at the same site. Chair Bonds, thank you for the opportunity to speak in favor of Bill 25-0134, eliminating the 50% loophole. is a long overdue and will provide workers who are more transient, like flaggers, an opportunity to earn a living wage.
Thank you very much for your testimony, Ms. Pinella. Can you make sure that we get your package of information? You indicated that you had testimonies that were attached to your testimony. I want to make sure that we get that.
Yes, I already emailed them.
All right, thank you. Thank you very much. Just want to make sure we have that. All right, now we will set up for, I think we're already set up. Okay. We're going to hear from Fidelia Velasquez and the use of a translator. I believe Carlos Pelot. Yes. All right, here we are.
I am here.
Ms. Velasquez, you can start when you're ready.
Empiezo. Mi nombre es Fidelicia Vázquez y yo vine a los Estados Unidos en 1998 para escapar la guerra de El Salvador, para buscar mejores oportunidades.
My name, Miss Vázquez. I just need, necesito solo un momento, pausas entre las oraciones para yo interpretar. I'm just instructing the witness to pause after a sentence or two so that I can interpret. My name is Fidelicia Vázquez, and I came to the United States in 1998 to escape the war in El Salvador and to seek better opportunities.
Yo empecé a trabajar con como un flagger con Marví en 2021 a $12.50 la hora.
I started working as a flagger with MRB in 2021 at $12.50 an hour.
No fui hasta que la Unión vino a contarme del mi mínimo de DC, que aprendí de que debería ganar 16.10 en ese tiempo. Después de escuchar las noticias, me alegré de la posibilidad de ganar 16.10 a la hora en un
It
mes.
wasn't, Ms. Vasquez, it wasn't until the union came to tell me about the minimum wage in DC that I learned I should be earning $16.10 an hour at the time. After hearing the news, I was glad to be able to earn $16.10 an hour.
En un mes, todas mis compañeras de trabajo se enteraron de las noticias de la unión y fue ahí que vino los abogados del jefe.
Within a month, all my coworkers found out about the union news, and that's when the boss's lawyers came.
A una reunión donde el abogado nos dijo que no era posible darnos el mínimo y que aquí los dueños no son la unión, son Marví. Y si no nos gusta eso, nos podemos ir. Siguiendo la reunión, me cortaron las horas.
We went to a meeting where the lawyer told us that it was not possible to give us the minimum wage in DC, and that here the owners are not the union, they are MRB, and if we didn't like that, we can leave. Following the meeting, they cut my hours and never contacted me.
Y nunca me contactaron durante este tiempo de desempleo. que cuando descubrí que despidieron a otros quienes hablaron con la unión fue de la misma manera y hasta toda una familia que despidieron por hablar con la unión. Me impactó bastante. Todavía estoy sin trabajo. Si me podían pagar los 16.10 la hora, me ayudaría a pagar a un abogado para sacar la ciudadanía y planes mi retiro. Les pido a la comunidad que corrija esta ley para que todos puedan ganar el mínimo y no solo los que trabajan toda la semana. Les pido que investiguen a sus contratistas y que se acerquen de que no se involucren en la represión sindical y paguen a los trabajadores los salarios que les corresponden debajo de la ley.
If the council member allows me, I can read the whole statement, or I can take it from where we were left, as you wish.
Yes, please do the whole statement. I actually have the statement here, but if you would put on the record the English translation.
Will do so, gladly. My name is Fidelicia Vasquez, and I came to the United States in 1998 to escape the war in El Salvador and to seek better opportunities. I started working as a flagger with MRB in 2021 at $12.50 an hour. It wasn't until the union came to tell me about the minimum wage in DC that I learned I should be earning $16.10 an hour at the time. After hearing the news, I was glad to be able to earn $16.10 an hour. Within a month, all of my coworkers found out about the union news, and that's when the boss's lawyers came. We went to a meeting where the lawyer told us that it was not possible to give us the minimum wage in DC, and that here the owners are not the union, they are MRB, and if we didn't like that, we can leave. Following the meeting, they cut my hours and never contacted me. It was during this time of unemployment that I found out that others who spoke to the union were fired. It was the same way I was let go, and even an entire family was fired for speaking with the union. It shocked me quite a bit. I'm still jobless. If they could pay me the $16.10 an hour, it would help me pay for a lawyer to get citizenship and plan my retirement. I asked the commission to correct this law so that everyone can earn the minimum and not just those who work all week. I urge you to investigate subcontractors and ensure they do not engage in union busting and pay workers their legal wages. End of statement.
Thank you very much for your testimony. Thank you so much. I'm sure that Councilmember Lewis George and I will try and have some follow-up questions for you. This is very concerning. And
Muchas
thank you
gracias
for the testimony. It's very important to have this.
Muchas gracias por su testimonio. Estoy segura de que otros concejales y yo tendremos preguntas de seguimiento. Muchas gracias por su testimonio. Es muy importante.
Next, we will hear from Steve Lanning. Steve, good morning.
Good morning, Councilmember. Good morning, Chair Bonds and members of the committee. My name is Steve Lanning. I'm the business manager of Laguna Local 11. We are the local affiliate of the Laborers International Union of North America. We represent more than 3,500 construction members across the Baltimore, Washington region. Many of our members live and work in the District of Columbia. In particular, we have more than 600 members employed on pipeline replacement projects across DC and Maryland, including any associated above ground traffic control. I want to start my remarks by thanking Councilmember Lewis George for introducing B25-0134 and thank Councilmembers Pinto, Parker, Nadeau, R. White, Gray, Bonds, and Henderson for co-introducing the bill. LiUNA fully supports B25-0134. The bill addresses a long-standing problem with DC's minimum wage law. Specifically, DC's minimum wage law applies to individuals who work, quote, more than 50% of their working time, unquote, in the District of Columbia. However, the law does not specify what unit of time is to be used to make the determination. For example, it could be 50% of a day, week, month, or year. A DC Circuit Court decision from 1972, Williams versus WMA Transit Company, determined that the unit of time to be used to measure the application of the DC Minimum Wage Act is the work week. As my colleague Zoli Pineda will testify, LiUNA has found that some traffic control companies are shuffling their workers around to sites in Maryland and Virginia midweek to avoid paying their employees DC's minimum wage. DC's minimum wage is the highest in the DMV. It will rise to $17 per hour on July 1st. In contrast, the minimum wage in Virginia is $12 per hour. In Montgomery County, Maryland, on July 1st, the minimum wage will reach $14.50 and $16.70 per hour, depending on the size of the employer. In Howard County, the minimum wage is currently $13.25 for small employers and $15 per hour for large employers. In Prince George's County and across the rest of Maryland, the minimum wage is $13.25 per hour. Local 11 also has several signatory contractors that specialize in traffic control. These contractors pay a family supporting wage with benefits determined through negotiations between the company and the union. Our signatory contractors, and therefore our members, are at a distinct disadvantage when competing against contractors who exploit the loophole and pay their workers as little as $12 and $13 per hour. The district's 50% minimum wage work week criteria is also out of step with surrounding jurisdictions and, frankly, the rest of the United States. Most local jurisdictions with minimum wage ordinances require employers to pay the minimum wage for every hour worked in their jurisdictions, or set a threshold of $2 an hour, 2 hours of work in the jurisdiction per week. Finally, LiUNA appreciates that the OAG, under the leadership of Attorney General Brian Schwab, supports this legislation and has provided the committee with testimony. Thank you, Chair Bonds, for the opportunity to speak in favor of B25-0134. Eliminating the 50% loophole is long overdue and will provide workers who are more transient, like flaggers, an opportunity to earn a living wage. It will also help companies that pay their employees a family supporting wage compete and win work across the DMV and eliminate the advantage of trying to game the system. Thank you.
Thank you very much for your testimony. Now we will hear from Ms. Salava.
Hi, good morning, Councilmember Bonds and chair members, council members of the committee. My apologies if I'm a little bit lost dealing with the family thing here, but I wanted to be present because this is a very important bill for everyone, especially for workers here in DC. My name is Nadia Salazar, and I'm the organizing director at DC Jobs for Justice, a coalition of labor organizations, community groups, faith-based organizations, and student organizations dedicated to protecting the rights of working people here in the District of Columbia. We support community struggles and promote racial justice to build a more just society here in DC. Our membership is made up of around 60 plus organizations that work with and for communities here in DC for over 20 years. At DC Jobs for Justice, it is part of our mission to give priority to the struggles impacting the most vulnerable workers in our community, to end wage theft and to ensure that all workers have dignity on the job. The bill addresses a long-standing problem with our DC minimum wage law. Currently, DC minimum wage law applies to individuals who work more than 50% of their working time in DC. And in 1972, a court decision determined that the unit of that time should be a work week. Since then, employers are seeking ways to increase their revenue and are aware of the more than 50% ratio and they're exploiting it. DC's more than 50% threshold is a huge outlier. The majority of the governments that have enacted minimum wage laws, 44 out of 59, use the threshold of 2 hours per week, while other 12 have the threshold of 1 hour per work week. This ratio is hurting minimum wage workers who are mostly people of color and Black folks here in DC. This exploitation will continue and likely worsen as the gap between DC's minimum wage, Maryland, and Virginia continue to widen. We urge the council to pass B25-0132 to protect workers and to allow them to access their rightful minimum wage for their work. This bill will protect our minimum wage workers who are mostly people of color, especially women, from exploitation. Thank you so much. I would like to yield the rest of my time.
Thank you to the entire panel for your testimony. I think you pretty much covered the fault lines in what is happening in the community. And it's very unfortunate that there is a gap in current legislation, because I can certainly attest that when we passed minimum wage law, the thought was everyone who worked in the city would have the opportunity to benefit from it. And certainly individuals who are working every day, very strenuous jobs, we want to make sure that they would definitely have an opportunity to benefit. So this is a very important hearing and an opportunity to really look very closely at what the law says and why. May I ask of the panel if they have a sense of why the employers are holding hard and fast to the current law and would feel that they are justified in not paying the minimum wage when they're in the District of Columbia and attempting to, as Ms. Valaquez said, attempting to pay a wage that someone might earn in another part of the jurisdiction. Mr. Lanning, I think you want to talk.
Sure. All right. Thank you, Chair Bonds. And if anyone else on the panel would like to chime in, in some ways we were being generous toward these employers. Quite frankly, what we encounter is employers who get caught not paying the minimum wage and then have no idea. They inform their workers, we're a Virginia-based company, we're a Maryland-based company, we don't have to pay the DC minimum wage. When we then inform the employer and the workers that that's wrong, that these workers have been here for the entire week, they hire a lawyer and the lawyer does the research and says, well, in fact, DC has this law. If you think they're entitled to it, prove it. And, you know, as the witness testified earlier, there's repercussions. Workers know this. Most employers coming in outside the area are not aware of this law on the 50% threshold. They just pay what they want to pay in blatant disregard to DC's laws. And then when they get caught, they find a lawyer and pay them whatever they pay them an hour to help them get out of the jam and then intimidate their workers into not proceeding.
So is it your opinion that the employers, the companies that have employees working in the city are not aware that they should pay the minimum wage, which is the DC wage when they're working in the city?
That is correct. So even closing a loophole, I mean, something that our partners like DC Jobs with Justice, Lionel certainly will, and certainly encourage the district government to educate all employers that when you're in the district, this is the minimum wage and you must pay it for every hour worked.
All right, okay. I'm just looking over my notes to see if there is another area that we need to examine as we are talking about minimum wage, you know, like work conditions. It just seems to me with the example of flaggers that there is maybe we also need to look at whether or not an employee who is working in the city also has the opportunity for a break. Flagging work is pretty difficult, and as it is, we're talking about flagging vehicles, you know, steel and these, tons of energy that are in the roadway. And I'm just wondering if we need to think about water breaks as well, things like that. I would be interested in hearing about the working conditions of the flaggers in particular, seeing that so many women are in that occupation. So anyone who wants to provide us with some information, I would be happy to hear it now.
Is there a way we could pose that question to Ms. Fidelicia Vasquez in Spanish so that she could speak on her experience on flagging?
Señora Fidelicia, la concejal Bonds quiere saber sobre las condiciones de trabajo acerca de los flaggers, ya que hay muchas mujeres que son empleadas como flaggers en el Distrito de Columbia y las demás áreas. ¿Cuál ha sido su experiencia en ese trabajo específico? ¿Qué riesgos, qué dificultades ha tenido con su trabajo como flagger?
Bueno, como como experiencia, pues el trabajo es duro porque se pasa mucho tiempo parado, pero sí le dan media hora cada 3 horas, 15 minutos, porque 15 minutos la hace para recoger cono, para chequear, y 15 minutos para descansar.
Ok,
Cada...
un momento. So in reality, it's a hard work. It's hard work. You spend lots of hours standing. They do give you 30 minutes of break. They give every 3 hours, and they give you 15 minutes to pick up cones, 15 minutes to check other areas. ¿Puede continuar?
All right.
Sí, sí, como le repito, 15 minutos son los que dan de descanso. Pero en esos 15 minutos, si usted tiene que comer, come. Si no, pues, sigue siempre trabajando.
So as I mentioned, they give you 15 minutes of break. And if you are able to eat in those 15 minutes, then you do so. But if you don't have anything to eat in that time, you continue working.
All right. Well, I'm going a little beyond the scope of this legislation, but I appreciate learning that. And I think we need to know more about our workers and how we can help improve our work environment so that everyone wins. And especially those that has been identified as doing some of the grueling jobs, outside and in harm's way. So I appreciate hearing from the witnesses. I'm going to now turn to Councilmember Lewis George. She's been waiting patiently to have an opportunity to ask questions. Councilwoman.
Thank you so much, Councilmember Bonds. I want to come to Zuli and Ms. Vasquez. If anyone, I would love to hear you elaborate. How would receiving a full $17 hour minimum wage help you or the members you organize in DC? Why are the fixes in this bill so important for you?
La pregunta es, me gustaría saber de usted, señora Vázquez o señora Zuli, ¿cómo afectaría recibir un salario mínimo de $17 por hora? ¿Cómo afectaría eso su vida aquí, las condiciones aquí en en DC, ¿cómo mejoraría? ¿Qué diferencias haría?
So I could start and say that being paid the $17 an hour for the hours worked in DC will help families put food on the table, pay their bills. Right now, it's really virtually impossible to support a family on $13 an hour, and the fixes in this bill are important because it will stop workers like Fidelicia from being exploited. Many who come to this country, many are immigrant, many are women, and many are alone, and it's very hard for them to make ends meet.
Ms. Vasquez, did you have anything you wanted to add?
Señora Vázquez, ¿hay algo que usted quisiera añadir en términos de el salario mínimo?
Bueno, que el salario mínimo es bueno, ¿verdad? Porque ya tiene otro entradita para comprar la comida y pagar la renta, que eso es lo que es más útil aquí, la comida y la renta.
I'd say that this minimum wage would be a good thing. It'll allow us to put food on the table and to pay our rent, which are the main things here for us.
Right. Awesome. Thank you. Thank you for your testimony on that.
Muchas gracias por su testimonio.
Steve and Zuli and Nadia as well. Thank you for explaining the way the loophole or minimum wage qualifications harming LIUNA affiliated workers. What other types of workers or sectors face the same challenges? If you could give us some concrete examples.
Two in particular, I mean, you're going to have landscaping because of the nature of that work, that they're going to be coming Virginia, Maryland, doing a project in DC, going back to Virginia, Maryland, back and forth. And that opportunity presents itself. Again, I'm all but certain these landscape contractors are not aware of the 50% threshold. They just pay their workers what they want based on Virginia and Maryland law and have no regard for DC's laws until they find out and they hire their lawyer. Another one would be moving companies, again, because of that short-term duration of the work. They'll come in, do a 2J job, let's say in the district, and then go back to Virginia, do work there. And those are core industries that we deal with that you're going to find this. You do have some other elements in construction. These would be smaller, what they call fit out projects, where you go into an office building, you're just doing one or two offices. It may only last a couple of days. They're going to find that loophole as well. When I say find the loophole, after they hired a lawyer that they paid $350 an hour to tell them how to get out of this jam.
Yeah.
And I would also venture out to say that domestic workers, folks that are doing cleaning services with bigger companies that move around, that might clean one day in DC, might clean in Maryland another day, might clean in Virginia a different day. I can see there being, the loophole being used there as well.
Yeah. Steve, as you know, this bill strives to accomplish two goals. One, clarify the existing requirement to pay DC wages for all hours worked when someone qualifies as being employed in the district. And two, it creates a new requirement to pay DC wages for any occasional work performed in the district that totals more than 2 hours in a week. In LIUNA's experience, have you seen cases of employers paying workers DC wages for only their DC-based hours, but paying VA wages on Virginia job sites, even though that worker primarily does work on a company's district-based site? So in other words, that worker likely qualifies as a DC employee based on the second test in the minimum wage law, but maybe isn't being treated as a full-time DC employee for purposes of pay.
Trish, I guess my experience, I'm going to say no, only because most of these employers are based Virginia, Maryland, and that's what they pay. We don't care where you're working, and that's what we're going to pay you. I don't know how many times I've been told by workers, I said, you're not making the right wage. You're in the District of Columbia. And they said, well, our employer said we're in Virginia. We're based out of Virginia. That's all we got to pay you because it's a much lower minimum wage. And that's all we're obligated to pay you. And the employer and the employees accept that as fact. The employers just feel that that's what they're entitled to, regardless of what the law says. So unfortunately, I haven't really encountered that dynamic because most employers just seem to have a general disregard to what the district's minimum wage is and the requirements.
Got it. And Nadia and Steve both, as you noted, the current minimum wage law does not use a specific time measurement to determine who meets the 50% threshold. If you just look at the language in the DC code, it's unclear if this 50%, if this is 50% of their work each day, each week, each month, each quarter, each year, etc. It does not specify if this is a prospective look at their work schedule ahead or a look back on hours worked. Are these clarifiers the committee should explore in moving this bill forward for a larger overhaul of the minimum wage law? Are there additional clarifications in the minimum wage law we should be working on?
I'll just go, and then Nadia, if you want to chime in, or Zoli. Yes, and we several years back we took cases to the Office of Attorney General, and to their credit, they were very sensitive and frustrated. But the reality of their situation came to bear, which is we'd have to bring a case. We would have to show or prove. We have to have the workers go back months and prove that in fact this week they worked this many, the 50% plus in DC. They just said, you know, for the scope, size, the amount of hours involved, this is cumbersome. So that clarity would just empower the Office of Attorney General to quickly go after some of these bad actors.
Nadia, did you want to add anything? It's okay if not.
No, that's Steve froze. But no, I mean, we've seen it in the case of domestic workers, right? That we've had to, like, how long did it take us for us to put something in writing to make sure that their rights were dignified? And I think we have to get ahead of the curve, as Steve says, and make sure that we put these really, like, these specifics to make sure that workers are protected.
Mm-hmm.
And has DOAS been helpful in going after wage theft? Or do you only rely on OAG?
I can start. So we have a very deep relationship with the Office of Attorney General. Really grateful for Attorney General Schwab because with his collaboration, we've been able to uplift the voices of workers. We've released reports showing what DOES does with tipped workers, right? They're in action when they see that tip workers are not being paid. So we have that relationship of understanding that we have to find other ways for workers to get their rights protected. So I think the biggest piece is just expanding on the public awareness of paid family sick leave, expanding on public education, doing what the OAG does with us, with DC Jobs with Justice. They grant us funds to be able to put together all of these wonderful events, all of these wonderful flyers to let people know what the minimum wage is, what the tip minimum wage is, to do know your rights with our community. We do know your rights on what we call know your rights on site, which is basically being on the street, talking to someone and telling them about their rights, going through the full gambit of things. So I think it's an investment in the community that's necessary and a really, really strong look at DOES and how they're protecting workers currently.
Got it. Great. I will follow up with DOES on how they can be doing more here too. I think to be a great partner. I want to know, can you speak to, Nadia and Zuli, this is for you, can you speak to some of the gendered impacts of wage theft and why women are particularly vulnerable or disadvantaged when they are not paid the proper wage rates? And similarly, immigrant workers who do not speak English as their primary language, I imagine are also uniquely vulnerable. Can you illustrate these nuances?
Yeah, I will say that in construction, it's a very male-dominated field. So women, and when it comes to flagging especially, make up a good amount of the workers in those types of jobs. But flagging is a very dangerous job. And I heard from a flagger just the other day that a flagger got run down and that she gets berated on the daily by people just zooming by, just calling them names. And when they learn about the further injustices with the wages, that they're not getting paid correctly, they break down and they tell me, like this country, they're disillusioned with the American dream and that they're struggling really hard. And that they have family in El Salvador or in other countries where they're trying to feed and, they want to make it, but they're, they feel defeated. And so this is just one step in the right direction to, make these workers feel that they can put food on the table and that they could just live fulfilled lives, you know?
Yeah, I think there's so much well-documented, information about the impacts of people of color and women of color in what we consider low-wage jobs, right? And I think it was Institute of Women's Policy Research that said that women outnumber men in low-wage jobs. So 57% of women, 57% of workers paid under $15 an hour. That's a pretty big number. And just from my experience of organizing in the fields of North Carolina, where there were a handful of women, to seeing a handful of women in construction sites and now a growing number of women in those fields, there is never a protection for women in those sectors. There isn't a thought of, do you need a bathroom break? What happens when you have your period during that month? I remember hearing all types of stories of being in the field and having these very basic needs not even being thought of because the leadership is not women, right? There's no protections. So there are a lot of impacts of this legislation. Women are going to feel more empowered when they know they're getting paid the same as their counterparts, right? There's a lot to say with the inequities that we see in the field, particularly in male-dominated industries and construction and others. But I think it is super important for all of them to get this corrected.
Awesome. Thank you so much. Thank you to this panel.
Thank you all very much for your testimony. I just had just a follow-up as it relates to the legislation. How do you see the government providing follow-up whenever the information is shared with the government that there are violations? I am asking, are you thinking that we need a very specific office that deals exclusively with these kinds of matters, even if it's temporary, until we get things going? I'm encouraged by hearing that the Attorney General is able to provide grant funding, I'll call it that will help to pass the information in the community. But should we have a more official approach to this problem? Because our ultimate goal is to make sure that everyone who is in the District of Columbia not only has a job if they want it, but that they're paid fairly and in accordance with the guidelines.
I definitely agree with you, Chairperson Bonds. It's these issues need to be highlighted and need to be followed up on. But if I'm not mistaken, DOES is mandated to follow up with these cases, and DOES would be the office that takes these cases up. And if they were big enough, my understanding is that OAG does take some of the investigations on. But I think it's like focusing, as what I said earlier, in investing in LEUNA, investing in organizations that have direct contact with organizations, investing in language accesses at these agencies that sometimes can be barriers for workers to get information and to follow up on their cases. So I definitely agree with you, but I do think that there needs to be a deeper conversation of the accountability that the DOES does have to the workers who are already submitting their cases.
Yes, and I agree, and I'm aware that this is DOES's, charge. But what I'm really trying to understand, is there an immediate and an urgent need to protect a class of workers, those that are in very dangerous jobs and tend to be women in particular, that we need to sound the alarm and move forward, if with nothing else but a dedicated group of employees that are working to make sure that we have in place the requirements in order to protect this class of workers. That was my real concern. Not trying to grow the government, but just saying we need to provide services where the services are needed. It's my thinking.
Yeah, and Chair Bonds, I would just real quickly on that. I mean, as much as the district wants to be another place where you want to do business and the government's not there to play gotcha, that information education on the front end is great. I know within Department of the Attorney General's office, there are some attorneys there who will, based on information, even if they don't have a rock solid case, will send letters to an employer, making them aware of the laws. Once we bring them some basic information, whether it's unpaid sick leave, whatever, just saying, look, you may want to make sure you're aware of DC's laws, not actually bringing the case. Again, love to have that information out there beforehand. I know there's a whole bunch of businesses that come into the district in a given year, but that kind of proactivity to put them on notice that if you're not complying, there may be a complaint coming. So maybe you go ahead and proactively fix your problems now.
All right. Well, Mr. Lansing, you're making me think now we're getting to what should be our proactive plan, and how do we really address this kind of issue. Perhaps we need to, on an annual basis, send a newsletter or a informational piece to all of the employees in the District of Columbia so that they understand what is required of them. Now, reaching those that are in the metropolitan area, maybe that's a way. Maybe we can work with COG to make sure that employees in the region are also aware that this is the law in the District of Columbia. So just trying to think through, how do we solve this issue as opposed to just highlighting it?
Great question. I mean, part of the challenge is we come in after the fact. The contract's been let. The employer already, budgeted a job at a below DC minimum wage rate. And they're thinking, this complaint's going to cost me money. How do I fight it? How do I avoid it? And again, they'll pay the $350 an hour to a lawyer to fight it. But if there's a proactive approach with employers, with the local surrounding governments, you're not going to come in and do landscaping from Pennsylvania. You'll come in from Virginia and Maryland. So there is a certain designated group that will, that we know, the businesses that I think should be targeted, profiled in terms of, you need to be aware of this law. And these are the industries in which this predominantly happens, and try to get DOES to do that outreach initially, because that's always the problem. After the fact, the contract's been let, budgets have been set, wage rates are part of that budget. And the employer's thinking, I'm going to lose money, so I might as well fight this or scare my workers from speaking up.
All right. Well, thank you. Thank you very, very much. Thank you to the entire panel. And without a doubt, Councilmember Lewis George and I will be following up on this very important opportunity to talk with those who are on the front line. Thank you so much.
Thank you, Chair.
Next, we will entertain Bill 25-0130, short-term disability insurance benefit protection clarification amendment. And we have a panel. Again, Joanne Waiters, Laura Brown, Elizabeth Falcon, and Yael Sheffy. And so we'll bring them into the room and we'll begin our second panel discussion momentarily. And I see one person, maybe Miss Wade. Nice. Okay, we're ready to go. Looks like. All right, Miss Waiters, we'll begin with you, and we'll just move right along. And thank you all for joining us today.
Thank you very much, Madam Chair. Good morning, Chairperson Bonds, committee members, and staff. My name is Joanne Waiters. I'm with the American Council of Life Insurers. I'm here with my colleague, Steve Claiborne. Steve is our resident expert on this particular matter, and he will give our testimony and also respond to any questions that you may have. But we certainly thank you all very much for the opportunity to comment on Bill 25-130, the short-term disability bill. Thank you. Steve?
Thank you, Chairwoman Bonds and other members of the committee. My name is Steve Claiborne, Senior Actuary, Health Insurance and Reinsurance with the American Council of Life Insurers. The ACLI is the leading trade association driving public policy and advocacy on behalf of the life insurance industry. 90 million American families rely on the life insurance industry for financial protection and retirement security. ACLI's member companies are dedicated to protecting consumers' financial well-being through life insurance, annuities, retirement plans, long-term care insurance, disability income insurance, reinsurance, and dental, vision, and other supplemental benefits. ACLI's 280 member companies represent 94% of the industry assets of the United States. ACLI members provide the majority of private disability income insurance coverage in the U.S., including Washington, D.C. ACLI's members supports hundreds of employers and thousands of workers by providing short-term disability income benefits in DC. Right to the point, ACLI opposes Bill 25-130. This legislation seeks to go beyond the borders of DC to prohibit the reduction of short-term disability benefits based on paid medical leave benefits under the Universal Paid Leave Amendment Act of 2016. In addition, the legislation would allow civil actions and complaints related to any such reductions. Employers working in DC already have this responsibility through laws previously enacted that prohibit offsetting. Taking a step back, ACLI applauds the creation of the DC Universal Paid Leave Program. Over the past few years, paid family and medical leave has been a valuable benefit to DC employees by replacing a portion of their income that might otherwise be lost if they are absent to a medical condition or a family need. Non-statutory, also known as private short-term disability income, also plays an important part for DC employers' benefit programs. Such voluntary employer-provided short-term benefits supplement the benefits provided under the DC Universal Paid Leave Program. DC Universal Paid Leave benefits are not reduced. Once an employee has exhausted DC paid leave benefits, their short-term disability income policy could provide additional income protection through longer duration benefits and address the coverage gaps by providing greater degree of income protection through longer duration and potentially higher benefit amounts. While it is important to provide adequate benefits during a leave from work, wage replacement benefits paid during an absence for an employee's own medical condition should not exceed 100% of an employee's pre-leave pay. This is commonly known as overinsurance. This can result in an increased leave incidence and longer than necessary leave duration. Because short-term disability offsetting avoids overinsurance, the cost of non-statutory short-term disability insurance is kept reasonable and helps employers to retain this supplemental coverage for their employees. That is, short-term disability rates are adjusted down to address the decreased risk associated with this benefit coordination. The current prohibition against offsets is already leading to increased costs of short-term disability coverage for DC employers. This increase in cost could lead to scenarios where DC employers have to rethink the benefits offered to their employees. A bad scenario may result in lower income security for DC-based employees. Finally, this legislation seems to be directed to other state insurance departments, indicating how they should be approving short-term disability and handling approved policy provisions, instead of protecting the DC workforce, which again has enacted laws already in place to address DC employers. For these reasons, we ask the committee members not to support Bill 25-130. And I will just end by saying we will be following up with more detailed written statements. Thank you.
Thank you very much. It would be very, very helpful to have your written statement. So that is very important. Thank you so much. I want to understand what we're talking about today. And what I mean is, who pays the unemployment insurance? Where does that come from? How does that get in an account?
The unemployment insurance, meaning short-term disability, or the universal
Yes.
paid leave?
Yes.
Well, of course, the universal paid leave is 100% employer paid. And for short-term disability, the majority of the coverage is paid by the employer or self-funded, which is not part of this discussion. For some reason, that was exempted from the previous legislation to have it applied to self-employed people. So with that being said, the employer is the one who determines what they will provide or offer to their employees. And they're the ones that come to the table with the benefit plan designs that they would like to offer. And as any employer, or most employers, I can't say that it's all encompassing, they would want their employees after an experience to be able to come back to work and be fully productive for, in this case, DC. And by designing plans where they have offsets, because that's the basic premise of disability income insurance, it just provides whatever the benefit that's being offered with other sources of income, then that would be the level of benefits paid. Did that
All right. Yes,
answer
you
your
did.
question?
Yes, I just wanted to make sure we were talking about one form as opposed to collectively speaking about this. So thank you very much. I wanted to get that on the record. Thank you. Our next witness is Ms. Laura Brown.
Good morning. My name is Laura Brown, and I'm the Executive Director of First Shift Justice Project. Thank you for the opportunity to submit testimony today in support of the Short-Term Disability Insurance Benefit Protection Clarification Amendment Act of 2023, B25-0130. First Shift Justice Project is a legal services organization with the mission of empowering workers in low-wage jobs to exercise their workplace rights related to caregiving. One of the services that we provide is assisting DC workers in accessing DC paid leave benefits. We previously provided testimony in support of this bill in December 2022. Before that, First Shift testified in support of the Short-Term Disability Insurance Benefit Protection Act of 2021. At that time, we shared several client stories about how insurance companies reduced our clients' weekly short-term disability benefit amount because of their eligibility for DC paid family leave benefits. Because of the passage of the Short-Term Disability Insurance Benefit Protection Act of 2021, some insurers are now prevented from offsetting short-term disability benefits by paid family leave benefits. Now, when we have a client whose short-term disability benefits have been reduced because of paid family leave eligibility, we tell them that's illegal. Ms. Garrett is a high school social worker who gave birth last fall. She had not planned to apply for DC paid leave benefits for bonding until after she had used up her short-term disability benefits at the beginning of her leave. However, soon after she gave birth, she became aware that the short-term disability company was deducting $1,000 a week from her benefits based on an estimate of what they thought she would receive in DC paid leave benefits. After such a significant deduction, it was like she was receiving no short-term disability benefits at all, even though monthly premiums had been paid. She contacted First Shift, and we supported her in advocating for the restoration of her short-term disability benefits. The legislation at issue today has been introduced to close an unintended loophole in the 2021 law. B25-0130 amends the law so that it also applies to short-term disability programs established outside the district, regardless of the jurisdiction in which the policy was issued, executed, written, or delivered. The DC Paid Family Leave Program was designed to serve as wage replacement for DC workers who need to take leave from work to care for themselves or a loved one. While offsetting insurance payments by other income received during the applicable time period is generally permissible, to do so with paid family leave benefits would eviscerate the value of the benefits for many DC workers and undermine the intent of the Paid Family Leave Program. Permitting this offset transforms a government benefits program intended to financially support working families through medical crises and family transitions into government subsidies for insurance companies at the expense of employers and employees who pay the premiums. Short-term disability plans typically replace only 60% of an employee's salary, an amount that's not enough for many working families to cover expenses. If offsets are permitted, employees like Mrs. Garrett may receive little or nothing from their insurance company, whether or not they in fact applied for or successfully received paid family leave benefits. When the Short-Term Disability Insurance Benefit Protection Act of 2021 was passed, it was believed the law would cover all short-term disability insurance policies that apply to DC workers. The fact that this law does not extend to short-term disability insurance programs established outside the district is an arbitrary and inequitable application of the law that undermines the intent of the anti-offsetting provisions. Employers of DC workers, including national organizations or those based in other states like Maryland or Virginia, sometimes purchase insurance policies that originate outside the district. The Short-Term Disability Insurance Benefit Protection Clarification Amendment Act of 2023 will fulfill the intent of the initial 2021 legislation by making the offsetting provision applicable to all DC workers, no matter where their short-term disability insurance policy was written. Thank you for the opportunity to submit testimony regarding this law. We are grateful that this legislation was reintroduced and for the Committee on Labor and Workforce Development's commitment to ensure that all DC workers are able to fully access their paid family leave benefits.
Thank you very much for your testimony. And now I believe it's Elizabeth Falcon.
Hello, Councilmember Bonds. Thank you for the opportunity to testify today. My name is Elizabeth Falcon, and I'm the Executive Director of DC Jobs with Justice. DC Jobs with Justice has supported the creation and effective implementation of the DC Paid Family and Medical Leave throughout the advocacy and rollout of the program. I'm here to testify on this bill. I was the first member of DC Jobs with Justice to utilize DC's paid family leave program. When we emailed our short-term disability company while I was pregnant in the spring of 2021 to inform them of my pending leave, they told us they were not sure if they would provide me with short-term disability coverage due to DC's paid family leave program. I've included a copy of what I received from the company, but I will only read the last line. So if the member receives the max from DC, then there could potentially be no benefit payable from Guardian. So to go back a little bit, when I started at DC Jobs with Justice, we did not have a short-term disability program, coverage. But recognizing that as an employer, we have committed to offering certain benefits, we added short-term disability coverage to the expenses that we pay in order to make sure that in the event something happened to one of our workers, we would be able, they would be able to be covered in that time. So then to learn while I was pregnant and eminently needing to take leave that payments that we had made were being claimed that we were not owed any like insurance benefit as a result of paying the premium was very frustrating. So as an employer, DC Jobs with Justice pays into both programs. We pay the payroll tax dedicated to the DC Paid Family Leave Program, and we pay the short-term disability premium. As executive director, I was happy to do those things because I recognize that everyone on my team may have a medical need or grow their family and will need time to care. But I was stunned to get this news. The company was clearly trying to avoid doing what it was designed to do, pay for the coverage that we had purchased. I ended up having my child shortly after the emergency legislation clarifying the directive to insurance providers went into effect. So I was able to utilize both programs, and I appreciate the fast action of the council in addressing this issue. As Laura mentioned, this legislation now is really just to keep closing these loopholes that the insurance companies are trying to use to avoid paying out benefits for which folks in DC have already paid their premiums. I don't want anybody to end up in the bind that I did, both as an employer and as a worker. And I support the legislation to further ensure all workers can access both types of leave if eligible. Yeah, I hope we can move this legislation quickly to protect the workers who need it. And thank you for the opportunity to testify.
Thank you very much for your testimony. Ms. Shepherds? Okay.
Good morning, Councilmember Bonds and members of the committee. I want to thank you for the opportunity to testify. My name is Yael Shafritz, and I'm speaking today on behalf of the DC Paid Family and Medical Leave Coalition that has advocated for legislative action and more recently the implementation of a strong and fair paid and family and medical leave program in the district. Our coalition is made up of community organizations, unions, service providers, and small business owners who are seeing firsthand the positive impacts that paid family and medical leave can have, whilst also noticing the gaps and ways in which the program can be improved. We have, First Shift and DC Jobs with Justice are two members of our coalition, and I'm also talking to you today as the DC Director of Jews United for Justice, an organization that represents thousands of Jews and allies to advancing social, racial, and economic justice in DC. The Paid Family and Medical Leave Coalition supported the Short-Term Disability Insurance Benefit Protection Act of 2021 because we believe that the benefits of the Paid Family and Medical Leave program should be going directly to DC residents and not used as a way for insurance companies to avoid their responsibility to their customers and ultimately further line their own pockets. For that same reason, we support the Short-Term Disability Insurance Benefit Protection Clarification Amendment Act of 2023 as a way to close a loophole and fully support this legislation. Nearly everyone needs time away from work and at some point to care for a relative, deal with a serious personal illness, or welcome a baby. But many DC residents can't afford to take unpaid leave. And I want to put my Jews United for Justice hat on for a minute and say that in the Jewish tradition, we understand this reality. When working people lose the income they need to sustain and care for themselves and their families, that loss is a threat to their very existence. Prior to the passage of the Short-Term Disability Insurance Benefit Protection Act of 2021, some district residents saw their short-term disability benefits reduced due to their eligibility for DC paid leave. This left many families in the middle of a crisis unable to rely on the benefits they expected to receive. This practice by insurance companies is shameful, as they are denying benefits to those who had faithfully paid premiums and doing so at an expense to DC taxpayers. While the legislation passed in 2021 has played an important part in averting this issue, we are still seeing insurance companies use every excuse to refuse payments to individuals and families who have paid their premiums and in this particular case, insurance companies are claiming that programs established outside the district are exempt from this law, affecting many DC residents who, for example, are employed in Maryland or Virginia, or at national organizations that aren't based in the district. The DC Paid Family and Medical Leave Program is a lifeline to many working families and individuals across the district. But if insurance companies continue to exploit the program to line their own pockets at the expense of DC taxpayers and businesses, then we will not be able to see the full benefits of the program. DC residents should be able to access both the paid leave benefits they are eligible for and the short-term disability benefits they have paid premiums for, regardless of where their insurance policy was written. We need to pass this, the Benefit Protection Clarification Amendment Act of 2023 to fulfill the intent of the law, and by amending it to establish an extraterritorial application, making the anti-offsetting provision applicable to all DC workers, no matter where their short-term disability insurance policy was written. Passing this legislation will eliminate this arbitrary and unjust application of the 2021 law, whilst providing another tool for government agencies to ensure DC residents receive benefits they have paid for, both as an insurance customer and taxpayer. We support the passing of this act to help make that possible. And I want to thank you and the committee for all your work to help pass this legislation and generally the work you've done and are doing to improve the paid family and medical leave program. Thank you.
Thank you very much to this panel for your discussion of this important bill. Earlier, I was trying to quiz Mr. Claiborne about what are we talking about here today? And the reason I asked you, Mr. Claiborne, that question is because I know paid family leave. I know how we fund that. I know how we fund insurance policies that organizations have and individuals have. So when I was asking the question, I was trying to determine, you were making a point that the issue is offsetting. And from your perspective, if you pay out from a insurance company that is located outside of the District of Columbia, and you are going to pay on a premium that will help an employee inside the district, and that employee also is eligible and receiving paid family leave, that somehow that person is almost like double dipping. You mentioned the issue of higher amount. This person somehow is getting more than 100% compensation. That is why I was asking that question, trying to understand what are we talking about here. You want to help me unravel the statement I just made?
Absolutely. With the bill, I don't know the exact name, in 2021, the one that I was referring to as the law that was enacted that prohibit offsetting in DC for DC employers who purchase a policy within DC for their workers. What I was saying is, number one, the insurance companies do not reduce whatever benefits are paid by the universal paid leave for the individual's medical leave. With the prohibition of offsetting, you could easily have, for example, I think one of the witnesses mentioned 60%, and that is the typical short-term disability payment, 60% of the wages. So you have 60% being paid without any offsets by the insurance company. With the amounts that are received from the Universal Paid Leave Program, there could be a situation where that is over 100% of the pre-leave pay. What I had quickly said in my testimony, my apologies for reading as fast as I was reading, was that for private short-term disability policies, the pricing for group insurance takes into considerations any estimates that might be obtained when pricing the product. So having offsets helps to reduce the cost of that private short-term disability premium that usually the employer itself pays for. And what I was getting at is, if that is not part of the considerations, the cost will go up, and members have said that the cost for short-term disability has shown to be increasing for DC employers. As to my comments about this legislation seems to be going after state insurance departments and other jurisdictions, we'll take Maryland. Maryland Insurance Department, if I'm domesticated in Maryland, I, as the insurance company, who is licensed to do business in Maryland have to have my policy approved for being able to sell in the state of Maryland. And by sitting there saying it doesn't matter where the policy is issued or written, reading the black words of the bill, it's stating you, Maryland Insurance Department, can't approve policies that would have offsets. And that's what I was just trying to get at.
All right, thank you. I really appreciate you expounding on your point. I'm going to turn to Councilmember Lewis George. She came on, and then I may come back to some of the other presenters today. Councilmember.
Thank you to the entire panel. Laura, Elizabeth, I wanted to ask a clarifying question. For childbirth, short-term disability pays benefits for medical recovery only. Is that correct?
Yes, that's why there's a different amount of time that's available if you have a C-section or a vaginal birth.
Right. So DC paid leave covers either childbirth recovery or parental boarding. So these are two different types of leave needs. And right, that's correct?
Right.
Yes.
Only a person who is giving birth can access short-term disability when a child comes into a home, not the other things that paid family leave covers, which are second parents, whether that's fathers or another second parent, adoption, fostering. And again, just to not be too nitpicky, but the paid family leave program is designed actually for bonding. That's
Yes.
why it's so broad. It is for all parents, for the parental leave portion, is for all parents to be able to build that close relationship with their child. It is not specified that it is for medical recovery.
Got it. So why then would someone apply for DC paid family leave before disability plan if they have one?
But what's the question?
Sort of in sort of what was stated previously by another witness. I'm just trying to figure out if these are two different types of leave needs, then why then would someone apply for a DC paid family leave before disability plan if they have one?
Well, I mean, there's two different overlapping needs and eligibility, and the leave that people take is typically 12 to 14 weeks. And so the disability that they get, the insurance they get, is not going to cover the entire period. And then also it generally only covers 60%. So you're still looking to cover 40% of your income. I am on vacation and my family just got back from the pool.
Oh, okay. Don't worry.
A minute.
Okay. All right. I have a question for you, but I'm going to come back. I was asking because Mr. Claiborne said that workers need to apply to DC paid family leave first, but by doing so, you sort of negate your ability to take childbirth recovery leave. So I wanted to clarify that, which I think you have.
I mean, I think you would lose, and Laura is a lawyer and has seen more clients, and I've just had my own experience, but there's a ticking clock from the time that you give birth that you can take your short-term disability. So right. If you took paid family leave in the first 10 weeks, you would just not be able to get short-term disability payouts. So and then
sometimes even if you don't apply right away, like in the case of Miss Garrett, who the company presumed that she was going to be eligible for paid leave benefits. And so she hadn't even applied. And we help people coordinate what their benefits are versus the amount of time that they're taking off. And different people make different choices. Our job is just to give them what their options are. And so what Miss Garrett had decided to do was just take the short-term disability at 60% and then go to paid family leave and apply for those benefits, which are compensated at up to 90%, but for her would have been much less than 90% because of her income level, because it's capped at $1,050 a week. And so that's the choice that she had made. And then when she got her benefits, which weren't benefits at all, she was very concerned because her whole plan was kind of, up in the air in terms of like, the planning that she had done with her family.
Right.
And so it was a big deal. And just to be clear, the offset law, the anti-offset law, is not on the table here. That law already passed 2021. What we're talking about right now is the loophole that there are some plans where, presumably, or it's assumed, or at least short-term disability companies are arguing that, they can get around it. Now, that's never been litigated. So I'm not ready to concede that as a lawyer, but that the whole reason that this law was introduced is to clarify that is not permitted. And the other thing I'll say is that the benefits are absolutely being reduced. I mean, I could come up with a list of 10 clients. I used Miss Garrett because she was a recent one, but it's happening. And they are getting, notices saying we are offsetting because of paid family leave benefits that you were eligible for. So that's not a subject to debate. It's a fact.
Yeah, absolutely. Appreciate that testimony. Elizabeth, in your experience, how long does it take to resolve disputes with insurance companies who are trying to reduce your benefit payments? Does this negotiation process sort of risk negating access to short-term disability benefits, given that benefits are oftentimes limited to when someone is out of work or only available immediately following a medical procedure?
Yeah, so I'll just say I got lucky because the council did pass the first round of clarifying that included a local insurers, and we had a local insurer. So we ended up not needing to, but I was talking to Laura and saying like, look, I know a lot of people can't fight this. So like, I'm willing to kind of take on this issue if I need to, but like I said, I didn't end up having to, and the law changed before I ended up in that position.
Yeah. If an employer wants to adjust their own out-of-pocket payments for leave benefits, will this clarification law prohibit them from doing so?
Nope, employers can do what they want.
Yeah. And I'll just say, as an employer, we have a commitment to 100% paid leave for folks. And so that means we're topping off short-term disability and paid family leave. And so, but if we were starting from, and we set our benefits at the number of weeks that's paid family leave plus short-term disability. So if the short-term disability, which again, we've paid into, was to disappear, we would suddenly be on the hook for the 100% because paying 100% paid family leave is a value for our organization.
Yeah.
So it's either going to fall to the worker or to the company, depending on how committed the company is to offering like comprehensive leave.
Got it. And Yael and Elizabeth, you both want to speak to this. Why is offsetting a deceptive consumer? Why is offsetting a deceptive consumer a deceptive consumer practice? So sort of why is it unfair to both workers and employers?
You want me to take it? You want to take it, Elizabeth?
I mean, the reaction I had when I heard back from my insurance company, like, we're not going to pay you anything because DC has paid family leave after I had been paying into them for 5 years, like my jaw just dropped. That is not what I signed up for. Yeah. And, obviously like contract law is its own thing, but like, it was in no way made clear to me that essentially major parts of my, that I should expect major parts of what I was paying into to be voided by this DC law. And also, like, we started paying into it before DC paid family leave went into effect. So if there had been a major change, then we should have gotten a notice saying, because paid family leave has gone into effect, this will no longer be covered. There was none of that, right? Like, again, I'm the executive director, so I'm a worker and an employer. I see all of those communications that come to my organization. So yes, it is not like, it's not only what would generally be expected, it was not communicated in any way that I should have anticipated the response that I got.
Yeah, and I'll just add two things. I think it's a deceptive consumer practice, but also for businesses and employers in the district, businesses, nonprofits, whoever's doing the employing, is they're having to pay twice. If like the offsetting is essentially saying you have to pay twice for the same thing, which I can't think of other practices where that is the case, where the government is we're paying into government for one thing, and then a private sector is saying, well, now we don't have to give you the services that you have paid for, which just seems a little ridiculous. And I would add the piece to this specific clarification. Insurance is a national industry. There are local companies, but overwhelmingly it is national, or it is, in the case of DC, DC, Maryland, and Virginia are so tightly tied together. The idea that and Maryland recently passed paid family leave as well. Like we this is an expanding issue. It's not going to stay as a local issue, and I think the insurance industry needs to catch up with how to approach this from a consumer protection viewpoint nationally, because it's not going to remain a local issue. They can't keep doing that.
All right, that's right. And lastly, we've heard concern today that if a worker receives both DC paid family leave benefits and disability payments simultaneously, such that they receive more than 100% of their pay, that worker will use that as an excuse to not return to work. But does DC paid leave approve someone for medical leave benefits longer than what their medical provider says is necessary for recovery? I guess I'm having a hard time understanding the risk here when your leave is tied to medical necessity, and when you must remain a current employee at a company in order to get benefits. I guess folks aren't just leaving the workforce because they had a few weeks of benefits at 130% of their pay, right?
No, that's a fake concern. It's just not real. And it's not real too, like in the space that we work, which is a lot with working parents and pregnant women, like they get 16 weeks under the FMLA, and they're only going to get 6 or 8 at 60% under short-term disability. And so the idea that paid family leave is going to, some of them do go over 100, but it's so small compared to the body of people. We may have had one client for whom that was a reality, but for most, even if they get the benefits simultaneously, they're at 0 after 8 weeks. They don't have anything, or they might have the paid family leave for 4 more weeks, but they come to a point where there's not an equation. It doesn't equate between the weeks of benefits and the total amount that they need in order to get 100% wage replacement for the full 16 weeks under FMLA versus the actual leave they get under, the FMLA. So it's not the problem that it's being promoted to be.
Thank you. I know I'm over 2 minutes. Sorry, Councilmember Bonds, thank you so much.
Thank you. Thank you very much. And thanks for this discussion. As you all were talking, I was thinking very much about this offsetting, and also thinking as a consumer that we have the paid family leave in the District of Columbia. We have addressed offsetting as an issue for companies that are in the District of Columbia that are insurers. So Ms. Waiters and Mr. Claiborne, we're trying to address the fact that the insurance marketplace is all over the United States, and individual organizations make decisions about procuring the resource, maybe from Arizona or Virginia. And we are trying to make sure that we protect the workers in the District of Columbia. And so that's why we are have this piece of legislation before us to make a decision on. I too am very interested in the concept, Mr. Claiborne, that you presented that said, well, if you are an employee and you benefit from paid leave and you're benefiting from the short-term insurance, you might stay out longer. Let me ask you, looking at the benefits from that perspective, are most of the insurance companies that provide short-term policies, do they have a time limit on the number of weeks or days or as it relates to that you can take advantage of that particular benefit?
Short-term disability does have benefit periods. The major one that was discussed this morning or during the questioning just recently was the 6 to 8 weeks recovery from childbirth. That could be extended if there's ended up being complications from childbirth, but the 6 to 8 weeks is one of them. Many of the policies, short-term disability policies, are about 26 weeks. So depending on the medical records that are submitted, that would be usually the longest that somebody could be to be out of work.
All right, well,
They could be out longer, but that's when the benefits would stop. But more times than not, employers have long-term disability. And if that was the case, there would be that transition to the long-term disability policy.
So am I to understand that if I were an employee of an organization that has the short-term benefits, and I'm located in the District of Columbia, or I work in the District of Columbia, I would be able to take advantage of the paid leave program that we have, and also the short term. So I would maybe need the services for short term for 26 weeks.
I
And
think
paid
that,
leave, you see, is only going to do like 8 weeks or thereabouts.
right, I can see, depending on the situation of the individual, I can see 26 weeks occurring. I can see 13 weeks occurring. I think what's being lost in this is that my statements weren't all encompassing. Everybody's going to do this. Everybody's going to do this. The discussion has been really interesting to hear. And I will say there was confusion with regards to what was appropriately said by Laura and I want to say Elizabeth. I'm sorry if that's not your name. I just Miss DC Jobs. That the universal paid leave program, once you have a baby, it is bonding leave, and that's not covered under short-term disability. So I was sitting there going, darn straight they should fix that. But I think that has been clarified. I'm not the one at the insurance companies adjudicating the claims. I would hope that it has been gotten better since 2021. Doesn't seem like it from some of the things said. But where I'm trying to come from is short-term disability is actually an employee, it's a voluntary, it's a non-statutory product. Employers aren't mandated to buy or offer it to their employees. And what I was trying to say is if you sit there, you could leave it. I would love to work for Elizabeth to know that 100%. And many companies who self-fund do pay the person's wages. But to have this benefit, and the thing is, short-term disability, just going on the national average, is about 35% of the workers that are covered. So, take 65% of DC workers that don't even have short-term disability to begin with, and all they have is the universal paid leave, which, again, we're all for our industry is all for paid family and medical leave because we see it as a need across the country. And I agree with Yale in the sense that I hope to see it. And it is. It has, I think there's been 3 more states that have enacted legislation for PFML programs. As was mentioned, Maryland was one of them. But it just seems like there could be some overstepping bounds telling another state how they should be approving policies. Because these offsets should be described in the approved policy itself.
All
Councilmember
right.
Bonds,
Yes, Elizabeth.
I thought I had a, so I was thinking about an example kind of because you were bringing up examples and basically, so if somebody maybe like worked for a company in Arizona that went remote during the pandemic and they moved to DC, then, and their coverage, right, their company's coverage, they have a short-term disability policy that is based in Arizona, but now they live in DC. That worker, right, let's say, you know, that worker would not be able to access short-term disability, but because they live in DC, they would be able to access short-term disability. Whereas their neighbor who works next door down the street at the Target or whatever, like they would be able to access short-term disability and paid family leave, right? So what we have is a problem where simply because of where, like if they had exactly the same kind of birth, if they had exactly the same kind of like medical issues, simply because one of those, one of the coverages originates in DC and one of them originates somewhere else, that would give them completely different experiences. And I think that like to kind of ask your example of like, you know, asking like how much leave would people get? What we're saying is that really you could have very different experiences simply based on where the insurance coverage originates.
Yes, and I'm real clear on that. And that's why I wanted us to at least look at, you know, an example or two, because and then of course, the issue of short-term disability insurance being optional is another aspect of this. We probably will have to have more discussion about it in other forums as we begin to think about the options, and perhaps I'll talk with in fact, I will talk with the Business and Economic Development Committee, because the whole arena of insurancing is within their domain, and we do need to, you know, come together as it relates to being assured that our employees in the District of Columbia being treated fairly and have access to all of the resources that they need in order to, you know, continue in their job. So we'll be looking at that. I'm going to now thank this panel. I think we have killed the horse, and we're about to make glue. I'm sorry, I try to keep it, you know, a little levity to our discussions, but I certainly do thank you all so very much for your comments today. Some of these subject matters start out being plain and simple, and as we get into it and unroll it, pull the onion apart, we begin to see maybe we do need to have more dialogue. And I thank you all so very, very much for your dialogue today. Thank you.
Thank you for having me.
Thank you.
We're going to take 2 minutes and set up for our government witness, and we'll be right back. Thank you so very much.
Councilmember Bonds, I have to leave, so I'm gonna send you some questions for the DOES
Oh,
director.
excellent, excellent.
I have
I
to
have a
make-
list. Okay,
I know
good.
you already have a list. I'm sure we'll have duplicative, but because
No,
I'm
this
these
is a
towards-
subject matter we really need to
That's right.
push into. Yes, indeedy. Thank you so
Awesome.
much.
Thank you so much, and thank you to your staff.
Thank you for your partnership.
Testing the mic, testing the mic. Can you hear me? Thank you. Thank you, Chairperson. I don't know why they're doing it like this, because the regular channel is just showing.
But whoever's watching it from home, like you could see them watch.
We are back to continue our hearing this morning on 3 important pieces of legislation. Again, Bill 25-0033, the Commission on Public Compensation Establishment Amendment Act of 2023, and Bill 25-0234, Minimum Wage Clarification Amendment Act of 2023, and Bill 25-0130, Short-Term Disability Insurance Benefit Protection Clarification Amendment Act of 2023. We just concluded discussion on the Short-Term Disability Insurance Benefit Protection Clarification Amendment Act of 2023. We are now welcoming our government witness, Director Unique Morris Hughes, who is here from the Department of Employment Services. Dr. Hughes, thank you for joining us. We're seeing each other too much, I think, these days, but be it as it is. I'll now swear you in if you raise your right hand.
Perfect.
All right. Thank you. Do you swear and affirm your testimony and any statements that you make before us today to be truthful and complete?
I do.
Thank you. And you can proceed when you're ready.
Good afternoon, Chairperson Bonds, council members, and staff of the Committee on Executive Administration and Labor. I'm Dr. Unique Morris Hughes, Director of the Department of Employment Services. Thank you for the opportunity to appear before you today to testify regarding Bill 25-0134, the Minimum Wage Clarification Amendment Act of 2023, and Bill 25-0130, the Short-Term Disability Insurance Benefit Protection Clarification Amendment Act of 2023. Under Mayor Muriel Bowser's leadership, DOES is committed to furthering fair, safe, and effective working communities. As you know, Bill 25-0134 would require employers to pay district minimum wage rates when an employee performs at least 2 hours of work in the district for the same employer within 1 work week. DOES views this change as a prevention of a form of wage manipulation. Wage manipulation disproportionately affects lower wage workers who may be already struggling to make ends meet. The impact of wages that are essentially lost because workers can be paid the lower minimum wage of a neighboring jurisdiction rather than the district's minimum wage quickly adds up. DOES believes, based on our work with other wage-related complaints, that wage manipulation may also disproportionately affect women, people of color, and immigrant workers. DOES has no objection to the legislation as it effectively ensures that individuals who work in the district are paid at the least the district's minimum wage rate. DOES's Office of Wage and Hour enforces the Minimum Wage Revision Act of 1992, as amended by the Fair Shot Minimum Wage Act of 2016. By engaging in audits, to ensure district employees receive the appropriate minimum wage. OWH investigates complaints of noncompliance to hold employers accountable to the district's wage laws. Under the current law, a person is considered employed in the District of Columbia and is entitled to the minimum wage when 1, the person regularly spends more than 50% of their working time in the District of Columbia, or 2, the person's employment is based in the District of Columbia and the person regularly spends a substantial amount of their working time in the District of Columbia and not more than 50% of their working time in any particular state. This amendment broadens the coverage of employees entitled to the minimum wage under the law to include those who perform at least 2 hours of work in the District of Columbia for the same employer within 1 week. DOES understands the principle of this amendment and considers the legislation to be aligned with current agency operations. In terms of the impact of the agency's day-to-day operations, DOES would like to raise the following considerations related to the education/enforcement for the committee's consideration. 1, The agency will likely need to devote, at least temporarily, additional resources to ensure that employers and employees are aware of their obligations and rights respectively under the amended law. This may include outreach, webinars to employers, website updates, updates to printed materials at job sites, and other general public education activities. The agency anticipates that, as with any new law, there may be an initial period after enactment in which we see higher rates of noncompliance as employers adjust to the new requirements. Agency operations may be impacted by a higher volume of complaints and a need for additional investigations. Regarding B25-0130, as the administrator of the district's paid leave program, DOES has a vested interest in legislation pertaining to this program. Neither the legislation nor the temporary version of the bill that is in place until July 26, 2023, have an impact on the agency's operation. Bill 25-0130 would prevent private market disability insurance companies from offsetting payouts they owe based on a policyholder's receipt of the district's paid family leave benefits. DOES's scope is limited to determination of eligibility and administration of benefits and is therefore unimpacted by enforcement or regulatory responsibilities pertaining to this bill. Workers are often entitled to both the district's paid leave and their own short-term disability benefits, as they can be utilized for different purposes. Knowing the positive impact that paid leave provides, the agency does not object to this effort to ensure that workers can utilize the benefit to which they're entitled without interference or confusion. Chairperson Bonds, thank you again for the opportunity to testify. I look forward to answering any questions you may have at this time.
Thank you very much for your testimony. I wanted to just start with a couple of questions here. My colleague wanted to make sure that you had an opportunity to respond to a few questions here. So let's talk a little bit about the minimum wage.
Sure.
And the question is, do you have any data on how many wage theft cases and complaints that you receive related to the minimum wage loophole?
Not on what she's describing as the minimum wage loophole. We don't have that sort of data available. We do have high level information about, wage theft complaints.
All right. And when you talk about wage theft complaints, do you have any of that data that you can share with us today?
Sure. Let me have my team pull some for me. First of all, I think it's important to clarify what we consider a wage theft complaint. A wage theft complaint means an aggrieved employee believes they were not paid at the accurate rate, that they were not paid fully for the hours worked, that they may have been incorrectly, as an example, paid for sick and safe leave in which they're entitled to. So those are just a few examples of wage hour complaints. In FY22, there were 342 wage theft complaints received by DOES. Of those, investigations were initiated for approximately 100 of them.
Okay. And of the 100 that were investigated, how many were further processed? That is, you reached a conclusion that the complainant was correct in their assumption.
So there are usually three things that occur. One, we could, if we see the need to, we could make a referral to OAG. This happens regularly. Two, we bring in the aggrieved employee and employer and see if we can work out any differences and come to a resolution. Or three, sometimes the employer acknowledges that there's an accounting error, mistake, or an issue, and they resolve it. I would say approximately nearly 50% of the 100 are closed or resolved, and probably fewer than 30 or 40% are referred to OAG.
All right, so of the 242 that were not investigated, what is your filter, your screening process that would help the public to understand that they may feel that they want to complain, they lodge a complaint, and how do they understand what is a complaint that the agency can follow up on?
Sure. So let me talk through the process. When a complaint is received, DOES assigns a compliance specialist to the case who reaches out essentially to validate the claim that is being made. Now, not all claims are able to be validated, and this prevents us from fully moving on. I'll also say when we have anonymous complaints, it also makes it somewhat difficult to validate a complaint, but our compliance specialists attempt and work with or try to go through the employer to have the claim validated. Now, some of the reasons why, and I think this speaks to your question, so folks at home can understand why a complaint is not validated or not investigated or referred on to the process, is because there is a lack of supporting documentation in place that does not allow us to proceed forward. So if an aggrieved employee calls and says, I believe that I should be paid $100 for working 2 hours, and there is no supporting documentation to substantiate the claim, it's difficult for us to move forward. So that's the process. That's an example of when we can't move forward a complaint.
So, Madam Director, this morning we heard from Iluna and Steve Lanning brought up a couple of cases. We also heard from DC Jobs for Justice. And are you familiar with both of those groups as complainants? Okay, all right. Can you give us some idea as to the number of complaints you receive from DC Jobs for Justice as an example?
Councilmember Bonds, that level of detail I do not have. But what I will do is I will ask my team if they can filter through the complaints that we've received and pull out those from Jobs from Justice and LIUNA.
I would appreciate that. And I'm thinking, the nature of the complaints that the witnesses discussed today were specifically construction flaggers. And I was trying to get, slowly but surely get down to the nitty gritty of the flaggers. Is that a category of complainants that you're familiar with?
I'm familiar most with, and we look at this, I tend to look at this from a 50,000 foot level, which is industry and then occupation. So the trades, yes, absolutely. We tend to see higher number of complaints from the trades and actually childcare, believe it or not. Flaggers, common laborers, journeymen, those are the sort of positions or occupations that we do see complaints. Okay. So I would presume flaggers could be listed as, a general or common laborers in construction.
Thank you. One of the witnesses this morning mentioned the issue of trying to organize flaggers at Washington gas sites. Just wondering, have you received any complaints about Washington Gas?
We have not received any complaints this fiscal year for Washington Gas.
Okay, thank you. Let's talk about the law, that the current minimum wage law, for instance, does not use a specific time measurement to determine who meets the 50% threshold. Is this 50% of their work each day or each week, or does it specify something else? Their work on the job in DC?
It's 50% of working time in DC. And that's very broad because working time could mean something different to someone who is holding the occupation of common labor versus, you know, someone who may be a childcare worker. So it's 50% of working time in DC.
And does it then, the way it would be reported would be based on the reporting that you get as a standard format from the employer. Am I correct?
I'm not sure. I'm not sure I follow exactly, but I think what you're getting at, I think, and you tell me if I'm going in the right direction here, is that the reporting is really based on this 3-part test, which is the employment based on DC in DC? It's not more than 50% of time in any other jurisdiction. And is it substantial time worked in DC? That 3-rule test is how then the employer is supposed to determine what is being reported.
And as you are giving description to this portion of the law, what is it that you think we can do better as a government to inform employers that work in the district or have employees that work in the district? They may be, as you heard from some of the testimony this morning, they may actually be based or a organization in Maryland, Virginia, West Virginia, wherever, but they do have work sites in the district and they have employees that work in the district. So how do we get the message to them about this important opportunity to pay their employees the minimum wage in the district when you're working in the district?
So I think first is to start what we're currently doing. So we have an annual mailing and emailing of the wage theft laws. It goes out annually to all businesses. We periodically do bus ads and we do Twitter and social media campaigns throughout the year. We also regularly do webinar and industry roundtables. We meet with businesses all of the time regarding labor law enforcement and compliance. We used to do, and it was taken away from us in this last VSA, a grant to community-based organizations who would go out in the community on our behalf and talk about the importance of wage theft. And the reason why this was so critical is because we had credible messengers on the ground talking to businesses and from communities, most are communities of color in which we see in industries we see the most complaints from. So that money went to OAG. And so we don't have that grant anymore, but that is one thing that we could be doing more of. And Councilmember Bonds, I'm sure you remember seeing those labor law posters, you know, the really large ones that are in the break rooms everywhere. Let's not forget that those are required to be posted everywhere, and that information is there as well.
Oh, great. So when we talk about those posters, which I'm certainly familiar with, and I believe many others are as well, how do we get that kind of, well, I'll ask, do we disseminate that information to organizations that are in other jurisdictions, but that they work in DC? Particularly, I'm thinking the contractors, the trades and what have you, as they are busy doing like repair work, construction work, short-term jobs. They come in every day with their ladders and their vehicles and their employees, and they do a job and they move on.
Yep. So we send the notice out to employers and businesses that have 50%, at least 50% or more of their workforce in DC. So if it was someone who was just occasionally coming into the district to work, we wouldn't send a notice. Now, the wage poster notice is actually, I believe, on our website. Yes. And there are many companies across this country that sell really fancy versions of those posters. I order them annually for all of our buildings, for DOES, and all of our break rooms. They're laminated. You can get them in color. I mean, some companies specialize in making each state's notice fancy. That we don't send out. Obviously, there's a cost to it, but the notice itself is available on our website, just not to everyone who does occasional work in DC, unless you want to download it.
Unless you want to download it. Okay. As it relates to, is this poster that you have on your website also in Spanish and any other languages?
It is. All of the language is covered by the Language Access Act.
All right. Okay. So the companies that you've heard complaints from tend to be childcare, flaggers, and you said journeyman. Journeyman as it relates to any particular?
So I would say construction as an industry, childcare as an industry, and hospitality and tourism as an industry are our three industries where we see the bulk of the complaints.
Those are the big ones in the city, other than healthcare.
Yes.
You pretty, or education, like our university. So you pretty much covered that. The whole field of employment pools that we have. All right. Did you hear any of the testimony this morning?
I did hear.
Okay,
Yes.
okay. So how can we better inform the companies, the construction companies, so that the employees know that they have rights and rights to our minimum wage?
I think the grants that we were doing, and we'd only done them for a couple of years. It was something actually initiated here in the agency before the funding was transferred to OAG, is a good way to have credible messengers both on the business and employer side and on the employee side, spread the word about not just the minimum wage compliance and wage theft laws, but all of the labor laws that they're responsible for enforcing and complying with. I think that is the best way. We currently, I believe, cover all of the bases now. And so I think there's very little else in addition to what we're doing that we could do. But I think maybe going back to the grants might be a really strong suggestion to do something different.
So going back to the grants you think will help us. So in the past, what was the level of the your pot of money for grants? Was it a couple of $100,000?
I think it was less than 250,000. I think we had 2 grantees. I remember, yeah, I think it was 100,000 or 125,000 each. It was 2 grantees. I mean, it was low cost. Well,
Okay.
low cost in my opinion, but low cost.
Are there any other portions of the minimum wage statute that you feel need updating or clarifying? And Louis George has added a point here. She said that yesterday the crime bill hearing brought out that we're not paying youth a full and fair minimum wage. You want to speak about that because that's important.
You know, and
Hear
we've
from
talked
you.
a little bit about this,
Yes.
council member. You know, there are a couple of ways to approach this. The summary, well, right now, there are no additional amendments that myself or the agency are seeking to make at this time. Most folks should know that effective Saturday, minimum wage will go to $17 an hour, amongst the highest in the country. So that will be effective Saturday, July 1st. In terms of what young people are making, the SYEP program was designed to provide both career experience and to provide wages. Our 22 to 24-year-olds do make minimum wage. So that is an option. Legally, 14 and 15-year-olds can't work in the district. So I think we're giving them an alternative and a competitive, alternative to being in camp by providing a workforce development experience where they can earn money. We also need to balance out that, we have adults that are also making minimum wage. And we've talked about this before, young people, it could potentially be an interesting conflict or a tension if mom and dad are making minimum wage and 14-year-old child is making minimum wage. I've heard arguments that the child should not make as much as the parent. The parent that's actually engaged in full-time employment is working. And some of these other internships and workforce development experiences are not the same as working a 9-to-5 job. And so it's an interesting debate and argument. We did increase the wage. I've heard from many people on this issue arguing all sides and different positions, but based on the slight increase that we did, the minimum wage being made by our older youth, I think we're probably providing the best that we can in this region right now.
Can you think of any other situations or circumstances when employers are not paying the minimum wage here in the District of Columbia?
When they're not paying the minimum
Yes.
wage, if they're not paying them lawfully, perhaps, and paying them cash or under the table, that's probably the only other instance I can think of when the minimum wage is not being paid.
And I suppose we haven't come up with a way to regulate cash payments.
No. I mean, no. It would be
don't
impossible.
really know about them. I got you.
Yeah, it'd be impossible.
Based on the industries that you mentioned, I would think that this bill could affect thousands of employees in the District of Columbia. Is that your thinking?
I mean, it could potentially. It may impact those that are not residents of the District of Columbia if they're coming into DC, doing the 2 hours of work is what I'm thinking. But I mean, I think it's hard to tell just because it's data that we're not currently tracking how many people and from what part of this region the impact, we would see the most impact.
I asked that question because it seems to me it could be very impactful given that our minimum wage in the district is amongst the highest in the nation. And we also already know when we look at our economy, more than 70% of those who work in the District of Columbia, they live in other jurisdictions.
Yes, and I think that's why I'm saying that perhaps there may be equal, if not greater, impact to those who don't live in the District of Columbia because people are coming into the district given how high our minimum wages. Maryland and Virginia do not have a Maryland, Virginia, West Virginia, Delaware, Pennsylvania, North Carolina. None of them have the minimum wage that we do. So it might actually impact more people coming into the district to who want to work and make more money.
Oh, definitely. And I see it impacting the workforce of residents in the District of Columbia and those that we are working diligently to get into the workforce of the District of Columbia.
Yes.
Let's talk a minute or so about the short-term disability legislation that's before us. The legislation is an opportunity for the district to extend this so-called, what's the term? Offsetting, as the insurance industry refers to companies that are located in other parts of the country, but have policies in the district. And I wanted to know from your perspective, do you see this law being a benefit to residents in the district?
My policy position on this is neutral because I really view us as the administrator of the program. And so I try not to take a strong policy position if I'm responsible for the administration of the program. I think it has the potential to be beneficial for claimants, but I think a balance should be struck with that of the employer needs and that of the claimant's needs. I understand the different policy positions at play here. I have the claimants want to make sure that they can take full benefit of any leave program, especially one that they may have paid into directly themselves, for their sake, for their needs. So I completely understand, and I think provision should be made, to that, because in the case of short-term disability where the employee is paid in, there is a financial stake that they have involved. So I certainly understand that policy position. I also understand the employer's policy position, that also have a financial stake in this. They're paying a tax. They're also in some cases, paying part of the premium. And desire to have a coordination of benefits, which I also think is reasonable or practical. And so I don't envy you, council member, in this situation, but what I can offer is that I think what makes the most sense is striking a balance between both the needs of the employer and the desires and needs of the employee.
I appreciate that. And yes, I know that you are the administrator of the process. So but I did want to at least get a feel for it. You heard some of the witnesses this morning, and the insurance industry, I think they pointed out that they represent about 95% of the insurers in America. Their position is perhaps that they feel they are a claimant is double dipping, in other words. And so that was the nature of my question. Well, whose money is it? Where does this money come from?
I don't know if they're double dipping, if the claimant has a financial stake in the short-term disability insurance that they have paid into. The employer is paying the tax for PFL, not the employee. So I'm not sure, I don't see the through line through that policy position and that argument. If in one case, the employer is contributing to the PFL fund, and the other case, you have employees that have paid into short-term disability. So you got two groups of people who have a financial stake. I don't see necessarily the complete through line or with double dipping. And I think there are safeguards in place to prevent potentially double dipping. Some employers offer very generous leave programs above and beyond what the District of Columbia Paid Family Leave Program offers. And in those cases, we have people who feel incentivized to do the right thing and not try to double dip because their employer has a leave program, and whatever that leave program is, and it might include short-term disability, may include, maternal, paternal, leave offered. But, I'm not completely convinced that there is a widespread attempt for double dipping and that's happening.
Thank you for that comment. I wondered if the agency actually does any tracking of the short-term insurance programs.
We don't track that. We don't have a view into that and that sort of data.
All right. Now, the insurance industry, again, was pointing out that we should mind our own business and take care of DC and stay out of other jurisdictions, pretty much, is what they were proposing. So I wanted to know, would we be the first jurisdiction to pass a law that affects insurance policies that originate in other parts of the country?
Council member, I do a lot of things at DOES. The only insurance program that I work on is unemployment insurance. And so I really think the folks at DSB are probably best positioned to answer that question. I unfortunately don't know the answer to that question.
All right. And so therefore, I assume that if this legislation was to move forward, it would not have any impact on the your agency's handling of paid family leave as a point.
I don't see immediate operational impact to our agency. But like I said, I don't envy you because, you know, there's two really strong policy arguments and positions here, and you know, ideally somewhere in the middle makes sense.
Well, yes, I'll venture out on that opening you've given me, because we as a government have already stated a position as it relates to paid family leave and short-term, and we've said the employee should have both if they can, and they should benefit from both. So the issue today is really, should we make a statement as it relates to what happens with companies that are not in the District of Columbia, where we do not regulate them?
Or is the policy position of the government that government itself is silent?
It is
on that.
But by being silent, we pretty much said, you know, this is okay. Yes, a very tough matter to.
Yeah, I'm not sure, you know, perhaps the drafters of the legislation did not contemplate this. And I'm not convinced that the silence was an affirmative yes. I think this is a blind spot or unintended consequence in implementing the legislation. Because I think that there may have been, I believe that the silence allows space for businesses to try to figure out, businesses and claimants to try to work together and figure out what's best. That's my interpretation. And based on the legislative history, that's why I think the silence exists.
I appreciate that comment, particularly when it's been pointed out that short-term disability is not statutorily mandated here in the District of Columbia and is optional, and therefore it continues to be a big issue. So I thank you very much for your comments today. Okay, well, thank you very, very much, Madam Director. Wanted to make sure we were as thorough as we can be on this subject matter. And thank you again for your time today. And thanks to everyone who participated in today's public hearing. If the public has any additional thoughts or would like to submit written testimony regarding these bills, please email it to CEAL@dccouncil.gov. That's CEAL@dccouncil.gov. The hearing record will close in 10 calendar days, which is Saturday, July 8th, 2023. This concludes today's hearing. With that, the time is now about 12:47 p.m. on June 28th, 2023, and this meeting is adjourned.
Thank you.
Thank you.